for the importance of customary practices in the lives of Pacific Islanders. As an organization, not only do we fight for women's rights, but we fight for religious and cultural identity as well. Nonetheless, our report reveals a severe tension between both these fundamental rights, and we believe international human rights is best placed to address this tension. More importantly, any recommendations that we have that touch upon customary practices is narrowly tailored to address a fundamental objective, and that is to break the cycle of violence against women and girls.
So I also wanted to say thank you to everyone for having us here. It's my first time in the Solomon Islands. It's also my first time with a motorcade, and you can bet I'll be telling all my family about that when I get home. It's incredibly exciting for me. So I'm Emily Christie. I am the Australian Pro Bono Associate at DLA Piper, which is a private law firm that exists worldwide. And you may be wondering why a private lawyer is standing up in front of you, particularly given the last panel that we had. We do a lot of pro bono work around the world, and talking to lawyers in the Pacific, I don't need to tell you what pro bono is. I know a lot of people do work for clients who pay them in chickens, who can't pay them anything at all, or friends of friends, people who can't afford the legal services. It's well known throughout the Pacific and in Australia as well. Being such a large law firm, our pro bono work on access to justice and rule of law is getting larger and larger, and is starting to look at how can we deal with systemic barriers, systemic issues to access to justice. And one of the programs we look at is violence against women and access to justice around the Asia-Pacific region. So when ICAAD came up to us, it was a perfect match of work that we could do, and we're very proud to be working with them on this particular project. So just to give you an idea of some of the work that we've done and are doing. So that's our global reach at the moment. And right over on the right-hand side in magenta pink is the work that we've been doing in the Asia Pacific in the last year. Quite a lot of that is on violence against women, and as some of you will know, it's also on continuing legal education that we've done in Samoa, Solomon Islands, Cook Islands, and Fiji. So I'll talk about the report and the methodology in a minute, but I want to talk about Margaret's story. This is not going to be a new story for anyone. There are going to be elements that a lot of you have come across in your work. So in April 2013, Margaret, who was living with her husband and her 2 children, went to meet her husband who was coming off the boat. And he had heard a rumour that she'd been unfaithful. So he took a bush knife and cut off her left arm and severely disabled her right. She was put in hospital for about 2 weeks after that. It went to court, and the judicial officer gave him a suspended sentence, released him immediately, and ordered him to live with Margaret, his wife, and their 2 children, and to look after them. The reasons that the judicial officer gave for not giving a custodial sentence were that the husband was a breadwinner. The husband was also provoked by the fact that his wife had presumably had an affair. There was no evidence of it, it was a rumour. And also, his wife had asked him to come home because she couldn't look after the 2 children on her own, particularly now that she had lost one of her arms and could not use the other one. So we have in that a number of gender stereotype issues. We have the fact that the husband is generally the breadwinner, and so the wife is economically disempowered. We have issues of provocation and the concept that the wife is supposed to be pure, submissive, loyal, that she's the property of her husband. And we also have a concept that men are almost justified in lashing out in passion and jealousy, that there is a justification behind losing control and on occasion beating the wife. So a number of issues all came together to mean that a brutal, grievous bodily harm assault leads to somebody not only being let free, but actually being ordered to live with his wife. Now, this is not an isolated case. It's not isolated to the Pacific. It is the type of consideration that will often happen around the world. So one of the problems is we don't know how pervasive that is, and we don't know what effect it's having on sentencing on average and in different countries. So what we did with Hansdeep and with ICAAD was to analyse around 900 cases across the Pacific to look at what considerations judges were taking into account that were around gender discrimination and what effect that was having on the sentence length and whether it was non-custodial. So that's the question that this report seeks to answer. It's what effect does gender discrimination have on the sentencing decisions of judicial officers, magistrates or judges in sexual and gender-based violence criminal cases? Does the presence of gender discrimination lead to a shorter sentence? And does the presence of gender discrimination lead to a non-custodial sentence? So why did we look at gender bias and gender discrimination? I think the story of Margaret provides a fairly good example, and I think a lot of the experiences that you will have in your courts means you know as well. But there are 5 main issues that UN Women have looked at as to how gender stereotyping undermines justice for women. And it leads to a lack of impartiality on the part of the judge. It also leads to considerations of whether a crime occurred. So some people may think that rape within marriage is not a crime. Somebody may think that if the victim doesn't struggle, it's not a crime. So it even affects it at that very basic level of whether or not there was a crime. It affects witness credibility, so issues of whether a woman needs corroboration because stereotypically women lie, they're not trustworthy, or they don't remember things well. So these are all stereotypes that aren't based in fact, but we as a culture have grown up with. There's also victim blaming issues, so that reduces the perpetrator's culpability. Issues around she was out drinking late at night, she had a relationship with him previously, she was a loose woman, she was drunk and having fun and talking to a lot of different men, etc., etc. She was provoking her husband in DV cases. And it can also then impede access to legal rights and protection. You're less likely to get a longer sentence, a custodial sentence, a domestic violence order. At the very basic level of reporting to police, all the way through to sentence, you will find barriers based on these gender stereotypes. And so that's why we wanted to look at it, because it can be such a crucial barrier to ensuring women access protection and that perpetrators are actually brought to account.
Now, this is probably the most surprising finding that we have. As you'll see, 58% of the victims of the cases that we reviewed are girls. And 28% of those victims, which is the highest demographic, are between 12 to 15 years old. Now, why is that important? As you know, the most important data on SGBV comes from the prevalence studies that were done in the Pacific over the last decade. But those studies only surveyed women and girls from the age of 15 to 49. So this data is telling us that the demographic that is actually most affected was never covered in that prevalence study. So that means a couple of things. Are communal environments more protective of reporting for girls? So this is the questions that, again, that are being posed. Does the prosecution prioritize claims of girls over women? Right? That's something only you can answer. Have the most comprehensive prevalence studies conducted in the region underreport the actual rates of violence? And we're already looking at an average of 60% for the entire region. So these are very critical questions that need to be answered, and we don't have those answers. But what we can show you is the data so that you guys can look and you can probe into understanding what is the missing gap in this process. What this slide is showing you is it's breaking down each of the contentious factors that we looked at. Gender stereotypes, customary reconciliation, and a combination of these factors. And what you'll see is, in both DV and sexual assault cases, a combination of these factors, gender stereotypes and customary reconciliation, play a significant role in how the percentage in terms of what those sentences are reduced. In this chart, the significance of this breaks down each specific factor and the impact it has on the final sentence. So for example, in DV, the starting average sentence is 2.14 years. The average final sentence is 0.9 years. In SA cases, it's 8.71 is the average starting sentence for sexual assault cases, but the final sentence is 5.19. So to provide some context, rate of aggravated assault, sexual assault cases in Australia and UK have approximately between 7.5 and 8.5 years as the final sentence. In the US, the average domestic violence final sentence is about 2.5 years, just to give a little bit of context to those numbers. So this is another big factor of the impact of contentious factors on custodial sentences, right? So are we imprisoning perpetrators who have committed pretty heinous crimes? And if you see in DV cases, a majority of perpetrators are not being imprisoned. And that is a huge issue when you're talking about accountability, recidivism. When you don't understand the gravity of the crime that has been committed, the likelihood for recidivism is going to be high. And we've seen that data. And again, I'm using Western context, but a lot of the data that comes around this has been developed by Western countries. So in the US, for example, 23% recidivism rate when there's an intrusive sentence, meaning there's an actual prison sentence and it's accompanied by potentially other factors. But that number jumps to 66% when there isn't an intrusive sentence imposed on a DV case. So that is a threefold level of recidivism when there isn't a proper sentence given for the gravity of the crime committed.
So what Hansdeep's shown you is all the contentious factors put together and the effect that they have on sentence. We then separated them out to look specifically at issues around gender stereotypes and look at issues around customary reconciliation and informal justice mechanisms. So you will know that in the courts, quite often the judges will look at whether or not there has been a customary reconciliation, apology, some other form of retribution that's been in there and mitigate the sentence. That we put into the category of customary reconciliation and customary norms. And then we also have gender stereotypes. So this first section is looking at gender stereotypes and rape myths. And these are just a number of concepts that we came up with. So I told you we brought out some of the language and some of the specific issues that the judges were looking at. And these are the factors that came up quite a lot in the cases we were looking at. So, as I said before, issues like he's the breadwinner of the family and therefore should be sent home to look after them. She argued with him, and quite often it can be arguments about giving back a box of cigarettes or lending money. She'd been drinking with the perpetrator earlier in the evening in a bar, and therefore he may have had some reason to believe she wanted to have sex with him. She didn't try and run away when she had the opportunity, meaning that he was either provoked or it can't have been that bad. Reliance on issues around the hymen, looking at whether or not the person was a virgin, how bad the rape was, rather than listening to the actual medical evidence that might be in place or the victim impact statements. The judges making a call as to whether or not the victim has been impacted simply by looking at how they react in the witness box. So you'll often see judges say, well, she didn't seem that upset, so the ongoing psychological trauma can't be that bad. Whereas women will often act in very different ways after being sexually assaulted or assaulted by their partner. And it's only now through expert psychological evidence that we're starting to understand the range of ways in which women may react and hide trauma or present trauma. And it often isn't necessarily evident within the court. Other ones are issues around he suspected her of having an affair or she wasn't looking after the kids properly, justifications around the violence based on how a wife and mother is supposed to act within the family. So I don't know whether I should ask for a show of hands, but we do have a few DPPs and solicitors in the room, whether people have seen any of these particular reasons, excuses, factors brought up either by defence or by the judge or anybody in the court in the cases that they've looked at. Just by a show of hands. Yep. A few people. people around. So one of the issues is then trying to figure out, well, how should I react? Should I appeal? Is this something that is legitimate to be looked at? Should the judge be relying on it? We have seen some of the appeal cases where these issues were brought up, and the appeals courts will sometimes uphold it, but sometimes say, no, these are completely illegitimate factors. But whether those appeals cases are then filtering down as precedent is difficult to tell at this point in time. One of the biggest factors that we saw time and time again was this one of provocation. So in DV cases, we saw in 34% of cases that it was considered to be a factor, and in the 10% it was in the murder and manslaughter factors. That's the way it goes. And provocation is one of those ones that, again, doesn't necessarily look like gender discrimination on the face of it, but it often reflects particular gender stereotypes. This concept of that there's a justification in certain circumstances for a husband or a father or an uncle to beat their wife, nephew, daughter. And often it can be issues around jealousy over seeing an ex-girlfriend or an ex-wife with another man, a response to nagging by the wife, the wife's refusal to have sex, or where a wife asks for the return of money from a spouse, was one or two that we saw. Another one was self-defense from an attack, where the perpetrator claimed that his wife was attacking him in cases where the actual response in self-defense was nowhere near proportional to the attack that they were fending off. So there are all issues around this concept that men are passionate, women should be submissive, and that there is a justification somewhere in there for the attack, which reduces the perpetrator's accountability.
Yes, I'd like to thank the presenters for a very informative and challenging presentation that they made. You have touched on sentencing for domestic violence and sexual offences, and talking as someone who was formerly on the bench, one of the challenges we face as judges when it comes to sentencing is the position of the laws of our country, as well as the need to be consistent in whatever sentences we pass in regards to all types of offences. The reason is that in consistency, we try to maintain the type of sentence or the level of sentence that were previously passed in similar cases, in similar circumstances. So if the sentences were low in the past, and if we pass higher sentences, then the chances of those sentences being reduced on appeal is very high, likely. The fact is, we are bound by whatever sentence was previously handed down in similar cases, and also by sentences approved by the Court of Appeal in the case of Solomon Islands, which is the highest appellate court in the country. So, in the case of Solomon Islands, we have sentences which range from 3 or even less to 7 years in the case of rape. And I remember in the initial stages where we tried to raise those sentences beyond those the number of years which has been set in previous years, we realized that those sentences were reduced when appeals were made against those decisions. So I feel that the only way we can really, unless the Court of Appeal members change their mind and see things different, the only way we can address this issue is through legislation. But that's how I feel. And I think it is incumbent upon those of us, law officers of this country, try and sort those things out through legislation. Because if we leave things to the Court of Appeal members or the High Court members without general guideline in the legislature as to how to deal with such kind of penalties, then everybody has discretion to decide cases which were dating based on previous precedents. So those are one of the, that's one of the difficulties that I personally faced when I was on the bench. I support I agree with we need to take tough action against people who commit violence against women and children, as well as sexual offenses. For the reason that I think it is now time that we change our attitude towards how we work with women. And in the case of countries like Solomon Islands, also maybe Papua New Guinea and Vanuatu, the Indonesian countries, we have, according to our custom, we have, we sort of look at women as some kind of an object that we own. As a result, when it comes to especially male judges handing down decisions related to crimes against women, we sort of have the mentality that it's not a serious offense, and therefore it affects the kind of sentence that we pass.
Thank you very much for the presenters. This is one core objective of PILON, an important area of focus. What gender discrimination has on sentences. A thought-provoking assumption or reality. I am sure you will find more time discussing this further among yourselves in the next 2 days. The report highlighted some significant issues and challenges that gave rise to the findings in the report, especially the data collected and compiled. The recommendations of overseeing role over sentencing by the Solicitor General and on training of legal and judicial officers. Please join me and my co-chair in thanking the speakers for their presentations.